Good evening. Welcome to another edition of Reasonable Doubt, brought to you by and sponsored by the Harris County Criminal Lawyers Association. I am not your normal host tonight. Jimmy Ardoin is out. I'm Justin Harris. I'm usually in the back, pushing buttons and bringing the show to you. We're also not joined by our normal co-host, JV Vela. Tonight we have our other producer, Victoria Fesoglu, with us.
Good evening, everybody. Taking JV's seat for tonight.
Keeping it warm. We will have JV and Jimmy back next week. Tonight we are joined by another candidate for County Criminal Court at Law benches. We've got Mr. Gus Saper running for County Criminal Court at Law number 11 in the Democratic primary. Thanks for coming on, Gus.
Thank you for having me.
And before we get into talking to Gus about his campaign, his candidacy, and his career, I feel like we'd be remiss tonight if we did not take a moment to recognize and comment the tragedy that happened yesterday on Valentine's Day in Florida. We've seen far too many of these incidents, and everyone from Reasonable Doubt and Harris County Criminal Lawyers Association would like to express their condolences to all those who were impacted by this, and this is a very difficult time for everyone. So our thoughts are with those folks tonight. That being said, we would like to move forward tonight with continuing our edition of candidate shows, and we're going to be taking calls. We usually open the phones up about halfway through the show, about 8:30. If you want to call in sooner, feel free to. Our phone number will be plastered up whenever you see it. If you see the number and you want to call in, ask questions of myself, Victoria, or particularly Mr. Saper, please do so. This is your chance, viewers, to call in and talk to someone who's running for office who will be impacting all the lives of those who come through that court. So whenever you see that number at the bottom, 713-807-1794, please don't hesitate to pick up the phone, call in if you have something to comment on or question. We'd love to hear from you, excuse me. So, Mr. Saper, if you would kind of introduce yourself, tell our viewers a little bit about you and your experiences and what you bring to the table.
Well, I am Gus Saper, and I am running for Harris County Criminal Court number 11. It's a misdemeanor court. I've decided to run after practicing law here in Houston for 43 years.
43.
I graduated from Texas A&M in South Texas. I'm a fifth-generation Houstonian. The old family homestead was at the corner of West Alabama and Montrose.
Wow.
And I grew up here, grew up in Briar Grove.
Okay.
Back when it wasn't in the city of Houston, and where I went to school used to be a dairy farm.
Really?
And the city limits was somewhere around Post Oak, where the Galleria is now. And I used to work at the wine garden store that was at the corner there. I think the Container Store's there now.
Mm-hmm.
Wow.
So, but, you know, I went to A&M. I wanted to be a fighter pilot. Obviously, I didn't make it because my eyes are too bad. But in the interim, I joined VISTA. I was a VISTA volunteer for a year, went to Atlanta, Georgia for training, and then went to South Carolina and lived in a mixed neighborhood. And by mixed, I mean on one side of the street was a black neighborhood, on the other side of the street was the white neighborhood, and they really didn't mix. And was there for a year, came back, finished school, and went to law school. Okay. And started practicing with Sherman Ross right out of law school, and was with him until he took the bench.
Wow, 43 years, that's a long career. Is there something about this time in your life that kind of compelled you to run for judge now?
I had been in court one day and something happened, and I walked out of the courtroom and I said, well, this isn't changing, and nobody is listening to me, and the only thing I could think of to do was to run for office. And so I went back and I told my partner, Ed Millett, I'm running for office, and of course he kind of laughed at me, and I called a couple of friends, Paul Schiffer, Paul, I'm going to run for office. Oh, no, you're not going to do it. And I said, well, yeah, I am. And it's a scary thought. In retrospect, when I think about it, I go, what am I doing? Mm-hmm. Because I've been used to being a trial lawyer for 43 years.
Sure.
And it's fun.
Mm-hmm.
Wouldn't do it if it wasn't fun. But by the same token, my wife likes to say you need to give something back. And I think I have something to give, and that's what I intend to try and do. Obviously, I have to get through the primary first and then make it through the general election.
Okay.
So we'll see what happens.
Was it something, I take it was something recent that happened in court that made you step out and think about changing your trajectory a little bit?
It was that day.
That day.
And I represented a young lady that had a DWI. It was her 21st birthday when she got the DWI, but she was a DACA recipient. And I had convinced the district attorney's office to give her a pretrial intervention or pretrial diversion.
And would you just, for our viewers who may not know, what does that mean, especially for somebody who does have DACA or would be a
deferred action
correct
recipient? Well, what does it mean for a pretrial intervention or diversion? It means,
what's the benefit of having that, especially for somebody who has?
It means you don't have a conviction,
right,
and you can get it expunged,
yes,
even though under the immigration laws they can still ask about it and you still have to disclose it. It's obviously better if it's been expunged and you don't have that conviction. So it's important. And it was doubly important because she had a high blood test, and normally they wouldn't have offered it, but I convinced them to offer it. All they said was, if you can convince the judge to accept it. And I said, well, the judge really doesn't have anything to do with it. It's supposed to be a contract between myself, my client, and the district attorney's office, and why are you leaving it up to the judge? Well, that's her rule, and that's how we do it in here. And I went to speak to the judge, and the judge kind of blew me off, and here I am.
Well, so that didn't end up happening for that client?
It did not.
Deal?
It did not.
So talk about a little bit more about what you're saying, because I think Victoria and I have experienced this, but you said that the judge shouldn't really have anything to do with the pretrial diversion or pretrial intervention. Why is that?
Well, the client doesn't enter a plea. It is a written contract that's drawn up generally by the district attorney's office. In DWI cases, they have a pretty standard agreement that's pages long. And the way they do it in Harris County, not necessarily in other counties, but in Harris County, they reset the case for the period of time the diversion runs for. In DWIs, it's never less than a year, and it's never more than 2 years. And so, because the case stays on the judge's docket, the judge wants to keep control over it. But she doesn't really have to sign off on it, or he doesn't have to sign off on it. It's really a written contract between the DA and the client and the defense attorney. And if the client does not comply with the agreement, it's not the judge that does anything. It's the DA's office that sends out a letter or an email to me or to the lawyer representing the defendant and says, your client's not in compliance. We are terminating the contract, and we're going to put the case back on the docket.
Okay.
I do these sometimes in federal court, and a lot of times, most of the time in federal court when you do them, and they're very rare there, the case gets dismissed. The contract that you've entered into has a provision that you've waived the statute of limitations for the period of time that the contract runs, and assuming that everything is fine, then at the end of the day, the contract's fulfilled and everybody goes their own way and you never have to go back to court again. If you don't, then they go back in, present the case to the grand jury, and you start over again. So it's really never on the judge's docket.
So do you see this as an issue with the district attorney's office by allowing the judge to be involved and not dismissing the case up front? Or is this an issue more with the judiciary and judges who try to inject themselves in a private contract between the district attorney and the defendant?
I think it's probably equal opportunity for both of them.
Okay.
many of these assistants stay in one court for a period of time. They have to deal with the judge on a regular basis. They don't want to upset the judge, and so they don't push the issue. It's hard for the parties involved to push the issue because they do have to deal with the judge in the long run. And so you tend to put up with things that normally you wouldn't want to. And you don't want to hurt your client by some position that you've taken as an attorney. And so you have to be careful about that,
right,
and cognizant of that. And sometimes you do, you know, push and push and push to try and get it there, especially if it's a judge you know,
right,
and have dealt with. Many of these judges I've known for 20, 30 years, either as former prosecutors. Jay Carahan was an assistant district attorney, tried cases against him. I tried a case in Judge Hittner's court against him years ago when he was an assistant United States attorney, and then he was in private practice, and I knew him when he was in private practice. So, and of course I've known him since he's been on the bench, and I enjoy being in his court, but he doesn't treat me any different than anybody else. But
right,
at least you know him, you can go in, you can talk to him, and you know that as long as you are taking a position that's not outrageous, he's going to at least sit down and listen to you.
right. It's that whole reasonable standard that we fall back on in the law so much.
Absolutely. And he doesn't make fun of you.
Right. That's always nice, right?
It is always nice.
You said trial was fun, and you're gonna miss that part of it if this works out, if you get on the bench. What is the most fun you think you've had in a trial, or what's your favorite part about being in trial, and what do you think that might translate to if you're a judge?
Well, being in trial is extremely stressful, and it's extremely difficult. And I still have an upset stomach right before walking in to pick a jury. And I've been known to end up in the bathroom sick just because the stress is so much, and you're so uptight, and there's so much on the line, and it doesn't matter whether it's a misdemeanor or a capital murder case. It's stressful.
Sure.
But
right,
once the jury's picked, opening statements are out of the way, then you're prepared, you're ready to go, and you don't have to worry about anything else except for that. And the easiest time is when you're in trial in some other town, because you don't have to come home and see your wife and kids. You're just concentrating on the trial, and you can do it and get into it and not worry.
And have the focus.
Then absolutely have the focus. Now, if everything comes together, great. It's when you go back to the office and there's a stack of stuff this high and 20 phone calls that have to be returned. And
that's maybe not so much fun.
You know, you get to take the dogs for a walk, and you get to, you know, take care of your child, make sure he gets to school or gym practice or whatever it is. So you're kind of away from that, and it's in some ways very liberating. Stressful, but liberating.
You know, I experienced that as well. Victoria and I have our own solo offices. As you sounds like you have a law partner, Ed Millett, but for the most part, when we're in trial, we shut our offices down. Yeah. And our clients don't quite realize that always. They see us in court, and if we're doing kind of a good job with our job, they may not realize. We're trying to make them feel like they're the only client we have. And if we get too good at that, I feel like sometimes when we're away because we're fighting for another client, you know, there's some, I don't know. You understand what I'm saying?
I do. It's been good. I've always had, I've always officed with other attorneys, whether it was in a partnership or not. I started out with Sherman Ross, and when Sherman took the bench, I was with Paul Schiffer and Jules Laird for a while. And then I was with Ron Tonkin. Ron was the former Attorney General of the Virgin Islands.
Oh, wow.
And went to work for the Justice Department, and then here in Houston with the OCDEF program, which is a drug interdiction program at the federal level, and then he went into private practice. One of our first law clerks was Sandy Bielstein.
Oh, wow.
Sandy was, I guess he was
Great
a lieutenant or captain in the homicide department of HPD.
Right.
And was going to law school at night, and he came to work for us. And great judge, great person.
Oh,
So,
absolutely.
but it's good because you have all of these people back at your office. If you're not there, they can at least answer a question. Make sure you haven't lost the case, or because they're there to answer the question and take it in. But you're right. I tried a case in Beaumont that lasted 6 months, and my partner was there, Ron Tonkin, was there with me. So we only had a secretary back at the office, and so it makes for a difficult time in keeping your practice together.
6 months. And you have practiced in different places, and not just in Texas. I think on your website it listed that you've also had some cases out of state. What do you think, has there been an experience maybe out of state that kind of shed some light on maybe how we do things here, things that you'd like to see done differently in court that you might implement or try to implement as a judge?
Most of the cases that I have had out of state have been federal cases, so it's kind of hard to compare. I've had a couple of state cases, but most of the time they're the federal cases. I had one in the Virgin Islands and walked into magistrate's court, and the judge said, "Well, I see you're from Houston." "Yes, sir, I am." He says, "Do you know Ron Tonkin?" And I said, "Well, yes, I do." "Why?" "Well, I was his first assistant when he was the Attorney General." So you never know who you're going to run into or where. But the out-of-state cases are the fun ones.
Right.
You get to go, you know, I did have 2 cases in Arizona that were state cases, one in Phoenix and one in Flagstaff. They were kind of related. And they do things differently. You don't, you know, Janet Napolitano was the state's attorney. I guess it would be like our attorney general, but they have more criminal power. And so I got to meet her, and obviously that's many years ago. And so they have different names for people, and you better have local counsel that knows what they're doing. I've had a little bit of work up in Colorado, which is fun, because we like to go there in the summer.
Oh, yeah. Oh, yeah. We have to anywhere north of Dallas during the summer.
But, you know, the rules of evidence are the same for the most part, unless you get someplace like Louisiana where it's a little bit different. Most all the rules of evidence are the same. Trials are going to be conducted pretty much the same way, and the lawyers are generally very, very helpful.
But they're, obviously being a fifth-generation Houstonian has some draw to bring you back, but you didn't get enough of a taste in those other states to stay there. So there's something about Texas that, and its law, that appeals to you, I guess.
I'm a homebody, and
okay.
I like it here. It's gotten, when I was growing up, I guess the population was somewhere around 200,000. And you see it build up and get bigger and bigger. I miss the smaller Houston. It used to be a little bit easier. I can remember being a kid and playing football at 3 o'clock in the morning out in front of the house when a constable shows up and, "What are y'all doing? Where's your parents?" Now you do something like that and the kid ends up in juvenile and you go, "Well, what happened?" "Well, he was just out playing football in the middle of the street making a lot of noise." So there was a hometown feel to it.
Right.
And I miss that. I hate the traffic.
Oh, yeah.
But I think everybody does.
Yeah.
But, you know, my family was here. My wife actually is from Mississippi. That's where I met her. I used to race sailboats, and after my dad died and my mother remarried, she moved to Mississippi, and so I used to go over there on weekends in law school and race sailboats. And
that's fun.
That's where I met my wife.
Wow.
Okay.
Some of the things we've talked about on the show in terms of hurdles that maybe are anticipated in court have been, you know, resets and docket control orders and people that have to keep coming back to court. And what do you envision some of the hurdles that you might want to tackle if you're on the bench, or things that you see now that you really think we could do better, or we need to do better?
Well, you were talking about resets and about clients having to come to multiple resets before the case was disposed of, and it's been a big issue within the defense bar about having to have our clients there every 2 weeks or every 3 weeks. Historically, though, what I remember is the reason for that was more defendants got out on bond and got appointed, court-appointed lawyers back when I first started. I made my living on court-appointed cases. And in misdemeanor courts, most of them were out of jail, and I was still getting the appointments. Well, that doesn't happen now. And it may change again with this new injunction that Fifth Circuit has come out with. But you got paid by the number of court appearances that you had, and you could only get paid for one case a day. So if you had 3 cases and you made 3 appearances on 3 different cases, you only got paid for the one case on that day.
I think now it's up to 2.
Yeah, big changes.
Big jump.
And you get some hourly rates.
Mm-hmm. $25 an hour.
But it encouraged the defense attorneys to keep resetting the cases.
Mm-hmm.
Oh, interesting.
And, you know, you don't know.
Which can be a bad thing sometimes.
Absolutely, it can be. I mean, I'm sure everybody's had a case where the client comes in and says, look, I'm guilty. I did it. I want it over with as soon as possible. And if you're appointed and you're getting paid by the appearance, that might not, that's a conflict between the lawyer and the client.
Mm-hmm.
And by the same token, you have defense lawyers that say to clients, look, you've received my letter, you've called me up, you want to know how much I'm going to charge. First appearance is $100, but the second appearance is $200, and the third appearance is $300. And then you keep getting resets and resets, and the fee keeps going up, and all of a sudden, instead of a fee being $300 or $400 or $500, it may be $2,000 or $3,000. Now, it may have been the case that it should have been $2,000 or $3,000 to begin with, but you've sucked this client in. Mm-hmm. So everybody's bears some responsibility for what's happening in terms of the resets.
What can a judge do? Because a judge doesn't have control over how the attorney's working, whether they're working, or whether the defendant, and that can be the attorney being the defense attorney or the prosecutor, or whether the defendant wants to reset the case or plead out at that point. What do you think a judge can do?
Judge Mike Fields had a policy, and I don't know whether he's still doing it. You would come in on day 1 and you'd sign a reset, and the case was set off for, I think it was 120 days, and it was set for a pretrial hearing on that 120th day or thereabouts, and you better have filed your motions 10 days in advance, and then you were going to go to trial in 10 days after that. You get a pretrial date and a trial date, and you better have taken care. He expected you to take care of business in that 120-day period. Now, a lot of cases that come through these misdemeanor courts are DWI cases, and we didn't have blood tests until fairly recently. And so you either had a breath test or no test, and those cases could go to trial pretty quickly. But now in DWIs, I don't know how long it's going to take to get a blood test result back. It could be 60 days, it could be 120 days, depends on the lab. Depends on who just got laid off or fired at the lab, right. And there's been a lot of that lately. Mm-hmm. Sometimes they were sending the results out to either DPS. I've had cases in some counties where I had to wait a year for a test to come back or a drug test to come back. And so in those instances, they ought to be able to reset those cases and not have the clients, either have the lawyers come in, but not the clients, or neither. But then you have to rely on the defense attorney to do his job, get on the phone, get on an email, contact the district attorney that's on the case. But when you are dealing in misdemeanor courts particularly, sometimes I'll go through 2 or 3 different lawyers before the case gets disposed of. You know, the first lawyer has already been there for 2 or 3 months, and it's assigned to her, and all of a sudden 2 weeks later she's out of that court, and you've got somebody else, and they're not familiar with things. So it's a staffing problem.
Right.
And it's particularly bad now because if you want to see an assistant district attorney, instead of going down to the 5th or 6th floor of the courthouse, you have to run out to the West Loop, to the Galleria area where most of the trial attorneys are. And if you've tried to do that, around Thanksgiving or Christmas at noontime,
good luck.
It's impossible.
Yeah.
And then the courts are staggered. Some of the DAs have to be there at 8:30. Some don't have to be there till 11. And sometimes everybody's either good or bad about returning phone calls and emails. And so it depends on who you get. I don't know whether it's getting better now with the new DA. I hope it is.
Yeah.
And my former partner, Tom Berg's now the first assistant, and so I can always yell at him.
Well, so it sounds like you recognize the issues and what the defense attorneys can do to speed things along and be efficient, what prosecutors in the district attorney's office from the top down can do to do the same on their end. But when you're elected, what will you as a judge, will you go to something like Judge Fields used to use? Because I don't know that he still does that. And I don't know if that's because of Hurricane Harvey and the displacement, or if that is something he stopped doing before August. But is that...
Well, things are so much different today than they were 6 months ago.
Right.
And it would have been a little bit easier to answer that question 6 months ago. Assuming that we get back into a building in the foreseeable future, I think it will be, and some of it's up to not only to the judge, but to the staff.
Right.
And the staff is always used to doing things one way. Mm-hmm. And obviously it's influenced by the judge, but it's also influenced by all the judges who sit down and come up with policy. And from experience, there's always some infighting. Not all the judges are going to get along. I will do what I think I can do in order to facilitate moving the docket at a regular pace, but not requiring people to be there all the time.
So you're comfortable with waiving appearances?
Absolutely.
Yeah. And
I think we've neglected to ask more.
We being the defense bar.
Absolutely.
Right.
We get into our own ways, and we're used to it too. And we want to see cases moved sometimes. The client may not want to. Mm-hmm. Nobody wants to have to plead guilty because they are guilty, but sometimes they need to. But there needs to be a reasonable amount of time, particularly on what most of the cases are. You're going to get DWIs and misdemeanor drug cases, and you've got to wait for a lab result because we know what happens when you don't wait for the lab result. Motions for new trial get filed or writs get filed, and you have to start over when it comes back not what they said it was. And so you have to deal with those kinds of situations and deal with them up front. Okay, it's a DWI case. It's a blood test. Well, maybe the rule ought to be that you reset those for 60 days to start off with. Come back in 60 days. And on the 60th day, when you come back, you don't have to have your client. Some of that is making sure the client doesn't disappear too.
Right.
And That's an issue now. With pretrial bonds, they're used to the bonding companies calling up, following up, and the cost was shifted to the bonding company, and the personnel was handled by the bonding company to make sure your client showed up. And it's incumbent on the defense attorney to call up and remind the client, you've got court, please show up, or at least leave the message. But as a defense attorney, if you've got a real heavy load and you don't have any help at the office, it's hard to do that, and people tend not to do that. And you're always going to have defense attorneys that don't do what you would like them to do, just like you will have assistant district attorneys that aren't going to do what you want them to do. And it's how you gently nudge them in the direction that you want that's important.
Right.
Because you have to work with them just like they have to work with you.
Sure. And sometimes for 43 years, there's people you've mentioned people who you've been working with, and they've changed positions and things throughout their careers and throughout your career. There are some people who you've been dealing with as prosecutors for the entire time as well, I would imagine. You've seen them along their entire career.
Most of the ones that started at the same time are not there anymore.
They're not?
At the district attorney's office. Either through attrition or retirement or being let go for whatever reason. I mean, some of them are, but not very many.
But the point being that we can have long careers together. And we
Absolutely.
have to remember that as we go through. To kind of go back to something you mentioned a second ago, I'm with you on the, defense attorneys don't ask enough. And I think we should make no mistake. I always say, and no offense against current judges or future judges, but I maintain that the most powerful person, when you're not in a trial, the most powerful person in the courtroom is the court coordinator, because they control the schedule and the calendar and the docket, which I guess are all three the same thing. But when a coordinator gives me a date that I can't do, I just show her my calendar and I say, all those colors on there are court appearances. So I can't do that week. Can I do the next week, or can I do the week before? And I've never found a coordinator who was unreasonable and would just absolutely not be willing to give me something. Tomorrow I have 5 cases on one court's docket. Just because I asked, 4 of my clients don't have to be there. And I can go in there and get the business done. And all of it's been, like you said, we're waiting on things that are not in my control. They're certainly not in my client's control. And they're not even really in the assistant district attorney's control. They're things that we're waiting on from labs or from videos from retail stores or body cams or dash cams for police officers, or MDTs, all kinds of things. And it's nobody's fault, but it's certainly not anybody's fault. If it is anyone's fault, it's not the people in the courtroom. So the only way I got what I needed for tomorrow, which was all 4 of these clients on the same day when they didn't need, and not having them to be there and wait around for me while I take care of the other one that I have, and while they watch me take care of each one, and I'm always worried, does this one think that I'm favoring the other one because I'm talking to him first? And it's stressful, and I don't need them there for any of that. I don't need their signature. I don't need to have them sign something. So I think you're right. Sorry to kind of get on my little soapbox.
That's
but
okay.
I think we just need to ask more. And if you ask, you might just be told yes.
And make friends with the staff.
Oh, absolutely. Catch more flies with honey than you do vinegar.
It makes a difference. And, some of the staff have been around a long time. Mm-hmm. And with many different judges. I know Ken Olive, who's no longer there, was in Jimmy Duncan's court for 22 years. Mm-hmm. Started out as his clerk and then was his court reporter. And then when Judge Jackson took over County Court 3, he was there until Judge Jackson left the bench. And now I see Ken all the time because he's helping run the Democratic coordinated campaign.
Okay.
Judicial campaign.
Okay.
And so he's been a great source of information to me and most all of the other judicial candidates on the Democratic side. So, yeah, he's been around. I was in trial in a JP court. First time I've tried a case in JP court, tried a civil case in JP court last week. And the constable, who was the bailiff there, had been with the sheriff's department when I first started practicing, he was the bailiff in Judge Duncan's court.
Oh, wow.
And so I hadn't seen him because he'd been out in JP court. So you do run across people that have been around for a while.
And in the spirit of asking for things, one of the issues that we've discussed on the show before has been the emergency orders for the orders for protective orders, emergency protective orders, and assault family violence cases. And, you know, most of the time those pretty much get routinely granted by judges when the prosecutor asks for them or files them. Is there anything that, as a judge, you would like to see either from prosecutors or defense attorneys in deciding if one of those should be granted or withdrawn or
Part
lifted?
of the problem is, especially now where the magistrates that are handling bonds are now handling some of these protective orders. Mm-hmm. I saw one signed by Joe Licata the other day. Mm-hmm. It was in my office today. The client was in my office today with one. And once they're signed, you know, they're good for 61 days, and there's just not too much you can do about it. And at the point in time where that order was entered, that defendant used to not have an attorney present. But I know that the public defender's office here now has attorneys that are assigned to probable cause court to handle those issues.
And for our viewers, would you just explain what is probable cause court? What does that mean? And
why it's significant that there now is a public defender there where there wasn't any representation for the defendant before?
Well, up until, what, 6 months ago, maybe a year ago, I don't remember when the lawsuit was filed to change the procedure in magistrate's court. The judges would, and I don't even know how they're appointed, but 2, 3, or 4 people were appointed as magistrates that had the authority to set bond, but for the most part they didn't set conditions. If you had a client or defendant that was charged with assault family violence, typically the bond was set at $50,000.
This is on a misdemeanor.
On a misdemeanor.
On a misdemeanor. Wow.
Until a protective order was entered, the 61-day protective order was emergency order was entered. And the judges were requiring, you know, if you were in County Court 3, that judge in County Court 3 wanted to be the one that signed off on that order. And so most of the time, clients don't want to pay $5,000 to a bonding company that they're not going to get back to get out of jail. So if you get arrested on a Friday night, you might be in jail until Monday, Tuesday, and if the docket was really heavy, it might even be Wednesday. Right. And if you didn't have a lawyer already, it was really difficult. And even if you had a lawyer and it was the weekend, it was a problem. Now at least, I see that these probable cause judges, magistrates, are signing off on those orders. And it is only recently that we had a public defender's office here in Harris County, and it is only very recently that they have hired, I think, 5 or 6 attorneys that do nothing but be there for bond hearings for both misdemeanors and felonies.
Right.
And I have not.
Those are such important orders because, I mean, for people that don't know, those mean that you may not be able to return to your home, right? Or you may not be able to return to your kids.
Well, doesn't necessarily mean you can't return to your kids. Most of the orders say you can't come within 200 feet of the residence. Right. And you can't contact the person, whoever it may be, your wife, your ex-wife, your girlfriend, whoever it may be, in a threatening manner. But then a lot of judges enter their own orders, which are for the length of the case, and it's called a no contact order, and they say you can't have any contact whatsoever.
Right.
And it makes it triply difficult, because what if your 13-year-old daughter's a witness?
Right.
And you can't even call. And when the attorney calls, they don't know who you are.
Right.
And you send out an investigator, and mom says, no, I'm not going to let my daughter talk to you or to your investigator. So yeah, it's difficult. But you also, I think as a judge, have to bear some responsibility to determine whether or not the relationship between the parties is as charged, and the people that the order is entered to protect are protected. The worst thing you can do is not protect somebody.
Right.
And so is 30 days long enough? Is 60 days long enough? Is a year too long? The 61 days is pretty much, once it's entered, it's going to stay there for 61 days. I don't think they will let you. That you can amend the terms a little bit, but you can't do
the terms.
But you can't do away with it entirely.
Right.
The no contact order, you can always go back to the judge and say, and it happens. I've gone back to the judge and say, look, judge, here's what's going on, or here's what's happened, or there's been a change of position, or, you know, and if you can get the DA on your side, better yet. And of course, there's also a court now that started a few years ago. It's a civil court, but it's dedicated to family violence cases.
The 280th District Court.
And you can certainly use that to your advantage.
And tell our viewers what that court does. They do just the protective orders.
They just do protective orders for usually family violence cases. There's a DA assigned to the court. I don't know how many DAs are assigned. I've only been over there once or twice. They will help the parties that desire that kind of protective order get one filed.
You can even get the ex parte ones too, the emergency ex parte ones if you fit the criteria. And I know there are a bunch of people that are running for that bench now.
Now, I have a kind of a unique experience with that, because I have a young lady that I know, not through my work necessarily, who was being contacted by an ex-boyfriend of hers, and she was being severely harassed, and there were threats, but they were very well-veiled threats. And she came to me because she knows the kind of work that I do, and she asked me for some help getting a protective order put in place. And I contacted the district attorney's office, and this was here in Harris County, so I called just the people who I know. And I know some people who are kind of mid-level up in that division, in that department, and I told them what was going on. And they said, well, let's have her come over and let's talk with her. And she did, and she did that, and she met with some of their social workers, and they asked her what was going on, and she explained it. And for her privacy and other people's, I'm not going to get into what it was, but I have a pretty high bar for, I'm pretty tolerant of things I probably shouldn't be tolerant of from other human behavior. This was alarming to me, and I was surprised how hard it was for her to get a protective order, just simply by the fact that they said, well, he hasn't hit you before. So since he hasn't been physically violent, and the thing is, that was just the next step. This was a pure escalation that you see in like the clinical sense of things starting out with text message and then escalating to social media and then bringing family and friends in and things like that. And then really bizarre behavior that was not very well veiled, but threats. And she was being told by people at the district attorney's office, well, we can't help you until he's actually physically been violent with you. And I was just...
Those are hard to get.
No, I just said that can't be right, because the intention of the law for protective orders is to protect someone before they're actually injured. And certainly, if they've been injured, to keep that from happening again. And she ended up getting one, but it took a lot of work on her part versus clients I have who the complainant didn't even want the protective order. And my client can't go to his own home that he owns and the protected person doesn't even own. And now he can't go there anymore. So it's an interesting situation.
You don't have to, my understanding is you do not have to rely on the district attorney's office to file an action in that court. You can do it yourself.
That's right.
Correct.
And I believe that court has a website that has the pleadings there
Yes.
that you can follow. And while I haven't done it, I've done research for clients and pointed that out. And so it's still up to the judge.
Right.
And it's just getting to the judge.
Yeah.
And I used to do family work when I first started, and I only did it for 2 or 3 years, and I hated it because people fight over their children, the children get in the middle, there are all of these emotional issues, and that is really, really stressful.
Mm-hmm.
And, you know, a family violence court is doubly stressful.
Oh, yeah.
And so, and sometimes you get people that are in there all the time, you get jaded.
Right.
And you've heard it all, and well, our time ought to be devoted to the person that's got the black eye, not the person who might get a black eye.
Right, and I understand that. What I was just surprised by, and we were going to head down the path of let's do it ourselves if she didn't get any help, but I was just surprised at how once someone's charged, they're just given out like candy. But if you're trying to prevent actual violence from happening and you have good reason to believe that it's the next step, that was just very difficult. And on one hand, I think it should be, the government shouldn't restrict our right of association and our freedom of speech and movement. But on the other hand, there are laws that are designed to protect people, and they should be used when it's appropriate. So, we're past our halfway mark. We're close to the end of the show. We have about 10 minutes left. We haven't got any calls yet, so please feel free to call in, 713-807-1794. I know I've been doing a little bit too much talking, but before I stop that, I want to ask you a question, Gus. So I have not been doing this. I've been doing this for about 6.5 years. You have much more experience than me, so I'd like to run this by you. I've talked to some people, and this is kind of an example that I use. I love analogies. I love to use examples to illustrate things. I have compared my job on the defense side to kind of a basketball game. And of that basketball game, we're talking about 24 seconds at one end of the court, one possession. Because in basketball, the ball changes hands, and then offense and defense changes. And that doesn't work for my analogy. So we're going to just do this in 24 seconds of the game. In my analogy, the defense is the defense attorney, and the client is the defense on the court. And the prosecutor and the district attorney's office are the offense. When you're on the offense in a basketball court, your only job is to get the ball in the hoop, right? And when you're on the defense, your only job is to keep that ball. That's your first job, keep the ball out of the hoop. The coach might tell you if you can get the ball away from the other team, that's even better. But keep that ball out of the hoop. And then in that analogy, I turn to the referees on the court. And I say the referees on the court are like the judge and the court staff. They don't really care who wins or who loses. They're just there to make sure that both teams are playing by the rules. And your example for what kind of pushed you into this race of being turned down and a judge intervening in a pretrial diversion agreement is kind of one example of that. But what do you think about my analogy? And as far as, because in my opinion, I think a judge should kind of be like the paint on the wall in a room. You don't really need it unless you look at it and you decide, hey, I want to do something with that. Or if one party needs something that the other party isn't providing to them. Otherwise, the judge doesn't really even need to be there unless we're in a trial situation, obviously. What's your take on that?
Well,
am I being oversimplifying it too much?
My take is a little bit different. I can recall speaking to Jimmy Phillips Jr., who's a pretty well-known attorney down in Brazoria County. He's been around for a long time. His dad was a state senator, and he used to tell me, Gus, you know, being a defense attorney, it's just a game, and your client is your ticket to play. And once you have that ticket, you better play hard, and you need to learn to play by the rules, and you need to learn when the rules need to be broken. And so, yeah, there's always going to be, a defense attorney's going to be pressing, and a district attorney or assistant district attorney is going to be pressing their point, and they're going to try and walk that line. And you have to, as a judge, keep them on the line and not over the line. And so if you're going to use that analogy, yeah, it's somewhat of a game. It demeans the system to call it a game, because everybody's life, and I know you don't. You and I know that.
Right. But
the person that's watching right now is thinking, a game? It's my life. I could go away to jail. Mm-hmm. I mean, my friend Jen Falk, who recently left the office here and is up in the district attorney's office in Dallas now, we used to get together and talk about these cases. And she called me up the other day. Well, actually, she got in touch with me on Facebook and said, I see you're running for judge. I'm really happy. Whatever I can do from up here. Mm-hmm. Why didn't you run for a district court bench? And I thought about it. And I did think about running for a district court bench, but I also thought, the people that you see in misdemeanor court, generally, for the most part, they've been there once before at the most. You get a lot of first offenders. You hope you never see them again. Mm-hmm. And you may be able to have more of an effect on their lives and offering some guidance than you would in district court. I mean, the worst thing that can happen to somebody in misdemeanor court is a year in the Harris County Jail. And as a practical matter, that equals 120 days in the Harris County Jail, because they've been so crowded that the sheriff has given them 3 for 1. Mm-hmm. So 120 days in jail is still very disruptive, particularly if you're losing a job or you're not home taking care of your kids. But it's not life in jail.
Right.
It's
not 4 years in jail.
It's, or 6 months in the state jail with no possibility of getting out early.
Right.
So it's a heavy responsibility. It's taken me 43 years to decide that maybe I have the temperament to be a judge and know enough and have the experience enough and be willing to give that back. My friend Paul Schiffer says, well, look what you're giving up. And I'll be giving up some income, obviously. Mm-hmm. But I'm pretty set, and so it's easier to do that. And I'll miss my friends if I get elected. Being able to, well, I'll probably talk to Paul every day, just because we probably talk 5 times a day anyway. But be that as it may, it's a little bit more difficult for people to just come in and chew the fat with you and what's going on. And I will have a very difficult time with friends calling me judge, because I'm just not used to it, and I probably will never get used to it.
You won't even let me call you Mr. Saper.
Well, Rob Fickman always worries about, what's he say, if you want to run for judge, you probably shouldn't be a judge. And that's one of his famous sayings, and he always talks about black robe disease.
Yep.
I hope to get away without having to wear a black robe.
Okay.
I just, it kind of elevates you really above and beyond. I don't know if you've ever been in Judge Ellison's court. Judge Ellison's a federal judge here. And I'm always impressed after he sentences a person in his court. He gets up off of the bench, he walks down to the defense table, and he shakes the defendant's hand and says, I wish you well. I hope, you do okay. And
I like that.
It's easier for him to do because he doesn't have the volume of cases that a misdemeanor court, you got 50, 100 cases. It's harder to do that. Yeah. But it shows that he really cares, and he's thought about it. Mm-hmm. And he is extremely well read, and he doesn't let it you know, he's a Rhodes Scholar. He doesn't let the fact that he is a federal judge interfere with being a human being.
That's good.
And so it's really nice to see. And there are a few of those judges over there.
I've seen a couple here in Harris County even. Judge Mendoza did that with
Absolutely.
my nephew on a felony case, actually. And it makes an impact because it made him think twice about stepping out of line on his probation.
Go through the hallways when we have hallways again.
Right.
You know, a lot of judges post letters on their outside in the hallway of kids, people that they have helped. Thank you letters. You did this for me, and I really appreciate it. And that's important.
Yeah, that's powerful.
Yeah. What do you think of some of the programs that are out there in lieu of jail time, and do you think that there are some that you're a particular fan of? You know, there's DWI court and drug court, and maybe you can tell us a little bit about some of the other programs and some that you like.
They're extremely important. The one thing I always worry about is do we put too much on a defendant? Used to be, well, on a DWI case, you had to have a victim impact panel, and you had to have a DWI school, and you had to do however many hours of community service. Well, Judge, my client's in school. Will you trade some school time for community service time? No, we want community service. You have to take all of these responsibilities into consideration. So some judges now will let you, okay, if you're in the DWI school for 4 hours, that'll count for 4 hours of your community service, and let that count. So you've not put so much on a person, particularly one who might not have their driver's license anymore.
Right.
And it's difficult enough getting around in this town, and if you don't have any money and you're forced to ride the bus and you have to leave to get to court at 5 o'clock in the morning because you have to ride 3 different buses to get to court, and you're 5 minutes late and the judge is going to throw you in jail because you're 5 minutes late, yeah, you have to think about those things.
Right.
And so it's a difficult situation to weigh those equities.
Yep. Well, Victoria, we made it.
Is that it?
We're getting told we got to wrap it up.
Wow, that flew by.
So, Mr. Saper, I want to thank you very much for coming on. Wish you the best of luck in the campaign. And is there anything else you want to say in the last couple seconds that we got while I'm getting yelled at to wrap up to the voters and the viewers?
Well, I want to thank y'all for letting me come on. And
Our
please, it's Gus, it's not Mr. Saper. It just drives me crazy.
Okay, Gus,
Thank you,
got
Gus.
it. Thank you.
You're more than welcome.
Well, on behalf of Reasonable Doubt and HCCLA, thank you all for tuning in tonight. Next week, we've got Raul Rodriguez coming to join us, and we hopefully will have the professionals back in these seats. Thank you all. Have a good night and a good week.